You can be legally married abroad, with official certificates and a recognized ceremony, but still have your UK visa refused. The reason? The Home Office doesn't automatically accept overseas marriages. Even the smallest technical issue, like where or how your marriage was registered, can mean your relationship isn't legally valid under UK immigration law. In this video, we'll explain exactly when the UK recognises overseas marriages and civil partnerships, what evidence you'll need, and how to protect your visa from being refused for avoidable legal errors. Let's get started. If you're applying for a UK visa as a spouse, civil partner, or unmarried partner, the Home Office must be satisfied that your relationship is both genuine and legally valid. When a marriage or civil partnership takes place outside the UK, it doesn't automatically mean it will be accepted in a UK visa application. Instead, the Home Office checks whether it meets two sets of legal standards, those of the country where it took place and those required under UK immigration law. Understanding this distinction is essential before you apply. For a marriage or civil partnership formed abroad to be recognised in a UK visa application, it must satisfy two key conditions. The ceremony or registration must be legally valid under the laws of the country where it took place, and there must be no legal barriers under UK law that would prevent the marriage or partnership from being recognised. This means both parties must have had the capacity to marry or enter a partnership at the time, for example, being of legal age, unmarried to anyone else, and consenting freely. If a marriage ceremony didn't comply with the legal formalities of the country where it happened, or if one party lacked the legal capacity to marry under UK law, it won't be considered valid for immigration purposes. It's not enough to show that a relationship exists. The marriage or partnership must also meet these legal recognition standards. When you apply for a UK spouse visa, the Home Office must be satisfied that you and your partner are legally married. If your marriage took place abroad, this means the ceremony must have been legally recognised by the country where it occurred. For example, a traditional or religious-only ceremony might be meaningful culturally, but will not count for immigration purposes unless it's also formally registered as a legal marriage. If the marriage doesn't meet those criteria, the Home Office will not treat you as a spouse under the immigration rules. However, if you've lived together in a genuine relationship for at least 2 years, you may instead qualify to apply as an unmarried partner, but you'll need to provide detailed evidence to prove that cohabitation and commitment. In short, the marriage itself must be legally valid both abroad and under UK standards. Emotional or religious recognition alone isn't enough. Civil partnerships registered overseas can also form the basis of a UK visa application, provided they are legally valid and recognised where they were formed. The Home Office will look at whether the overseas civil partnership is legally equivalent to a UK civil partnership in terms of rights and responsibilities. This means informal arrangements, symbolic commitments, or relationships that haven't been registered as civil partnerships under local law won't be recognised for immigration purposes. So, if your civil partnership was created abroad, you'll need to show that it was formally registered with a competent authority and carries legal status comparable to a UK civil partnership. When submitting a visa application based on an overseas marriage or civil partnership, the burden is on you to prove that it's legally valid and genuine, the Home Office will expect. A legally issued marriage or civil partnership certificate from the relevant authority, a certified translation if the document isn't in English or Welsh proof of identity for both partners, and evidence of the genuineness of the relationship, such as communication records, photographs, shared finances, or proof of living together. If one or both partners were previously married or in a civil partnership, you'll also need to include evidence showing that any prior relationship has legally ended. Remember, the Home Office doesn't just check that the marriage is valid on paper. They also assess whether the relationship itself is genuine and subsisting, meaning you share a real, ongoing partnership, not one created solely for immigration purposes. The Home Office takes the validity of overseas marriages and civil partnerships seriously. Even small procedural differences between countries can cause major issues for your visa application if you're not prepared. If your marriage or partnership took place abroad, make sure it meets both local legal requirements and UK recognition rules, and gather certified documents early in the process. Getting this step right could mean the difference between a smooth approval and a costly refusal. At Compass Immigration Law Limited, we offer 4 core services to make your UK visa applications easier. General advice. We provide expert guidance on requirements and evidence form filling to assist with completing the application form. Application checking. We'll review the application you have prepared prior to submitting full application package, where we provide all of the above and more. Our experienced immigration team are based in Bolton, but we help clients across the UK and internationally. If you require professional assistance, don't take chances. Let us guide you through every step. If you found this video helpful, don't forget to hit the notification bell for updates on the latest UK immigration advice. Got questions? Drop them in the comments below. We're here to help you navigate the complexities of UK immigration law. Use the details on screen to contact us today to get more information. We're here to help. If you've got a few minutes, check out the suggested video on screen now. Thanks for watching, and see you in the next video.